Welcome everyone to today's educational seminar, How to Be an Effective Advocate, A View from the Bench. Today is where we gather a panel of judges to share their expectations, experiences, suggestions for new attorneys and on how to be effective advocates and discuss the role attorneys play in addressing the access to justice gap. So it's my pleasure to introduce our panel. First, we have Judge Edmond Chang from the United States District Court for the Northern District of Illinois. Judge Chang was unanimously confirmed by the Senate in December 2010 as a U.S. District Judge for the Northern District of Illinois. When he began his service in early 2011, he was the youngest federal judge in the nation, and he is also the first Asian Pacific American Article III federal judge in Illinois and in any state of the Seventh Circuit. Before taking the bench, Judge Chang served as an assistant U.S. attorney beginning in 1999 and serving as Deputy Chief of General Crimes as well as Chief of Appeals of the Criminal Division. And before that, Judge Chang practiced employment and labor law at Sidley Austin, where he was a Pilley Fellow at the Chicago-Kent College of Law Legal Clinic. And in 2012, Judge Chang was awarded Pilley's Fellow Alumni Award. We next have Judge Alison Conlon of the Cook County Circuit Court. Judge Conlon was appointed by the Illinois Supreme Court on February 2nd, 2015. She presides in the Daly Center hearing civil cases for damages under $30,000. And before becoming a judge, Judge Conlon was a partner in the law firm of Barnes & Thorburg, where she represented people, businesses, cities, and villages in commercial and tort litigation. Before that, she was an assistant corporal counsel for the city of Chicago and a law clerk for Judge Charles Corcoras. And Judge Conlon has served on Pilley's board of directors since 2011. And we are also happy to have Judge LaShonda Hunt of the U.S. Bankruptcy Judge for the Northern District of Illinois. Judge LaShonda Hunt was appointed to a 14-year term as U.S. Bankruptcy Judge for the U.S. District Court for the Northern District of Illinois in December 2016. Before that, Judge Hunt served as General Counsel of the Illinois Department of Central Management Services, Legal Counsel of Illinois Department of Corrections, and Assistant U.S. Attorney. And previously, Judge Hunt practiced at the law firm now known as Denton's, where she was a Pilley Fellow at Legal Assistance Foundation, now Legal Aid Chicago. And Judge Hunt has also served on Pilley's Alumni Network Leadership Council. So thank you all for being here. Excited to have such Pilley connections here as well. And so for the first question, let's go down that line, starting with Judge Chang, and tell us more about, there are several paths to the bench. So give us a little bit more detail and insight in how you came to be a judge and your process that brought you to the bench.
Yeah, sure. Thanks for the invitation to speak with Pilley Fellows and interns. I did, of course, start out in a Pilley Fellowship, as Brent mentioned. It was at the Chicago-Kent Legal Clinic, and I practiced criminal defense law there. And like many of you, I'm sure, are experiencing now, it was just an eye-opening, transformative experience. I really got to appreciate what happens when the state brings the entire machinery of law against someone. And how that impacts not only the accused, but also the accused family. And I really learned, as I hope you all will in the next couple of months too, a lot about client relationships and really being patient and trying to guide them through what is often very difficult circumstances. From there, I clerked on the district court with then Chief Judge Marvin Asprin here in Chicago, and he's now a colleague of mine. So I spent 2 wonderful years clerking for him. And actually, before that clerkship, I spent a year clerking for a judge on the Sixth Circuit in Detroit. And that felt very much like an extension of law school, a lot of research and writing and draft opinions. After those 2 clerkships, then, as Brent said, I practiced labor and employment law at Sidley. And I thought it was a wonderful experience. I learned a lot about civil litigation there, and also was given the opportunity to do a lot of pro bono work. And hopefully all the firms that you are committed to are continue to show that dedication to pro bono work. Then I did spend about a decade in the U.S. Attorney's Office, and I mean it was a remarkable job. I think the experience in being able to step up and represent the United States every day in court was it was a sobering responsibility, but it was just one that I felt like was a privilege to have. And so it was a wonderful public service job. Now, the nomination process was interesting. I first applied to be a district judge in the last year of President George W. Bush's second term. And so at that time, the decision-making for the nomination was for the recommendations for the nominations was in the hands of Republicans. And I'm not a Republican. I'm also not a Democrat. Like I'm not a, I don't have a partisan. If I never registered for any political party. I'm an anarchist, but I'm not. I just have never been comfortable with the
Oh no, I think we lost Judge Chang. In the meantime, Judge Conlon, do you want to jump in with your background on how you got to the bench?
I will try. I feel like he's about to make a really good point. Look at
there
he is. Okay,
so
I know.
I'm yeah, my apologies. The judiciary's, your federal taxpayer dollars at work. I'm literally in chambers. I'm literally hardwired into the network. And, so yeah, so let me just accelerate. I'm sorry if I'm not sure exactly what point I dropped off, but I think I was just making the point that I'm not a member of either political party. And so the first time around when I applied, it was with a Republican in the White House, and I was a finalist. Went out to Washington, D.C. and interviewed there. I did not get the nomination that time. So this is summer of 2008. And another lawyer, Jay Tharp, who is now a colleague of mine, was nominated, but his nomination never made it out of committee because it was just too late in the election year. So then, of course, President Obama wins in November. And now Senator Durbin is, of course, the Democrat, senior Democrat from Illinois. He makes the recommendations. And so I thought, oh, I have no chance. I was a finalist in the Republican process here. But the chief of staff for Senator Durbin said, no, we remember vetting you. You should apply again. And I applied. And so for all of the partisan bickering, that is out there, it was a very nonpartisan process. So it's now been about a decade on the bench.
Well, thank you for that. Judge Conley?
Okay, thank you, everyone. Nice to be here with all of you. My name is Alison Conley. I graduated from law school in 2000 and came back home to Chicago and clerked for Judge Kokoris, who is a colleague of Judge Chang's and Judge Hunt's over in the Northern District. Then I worked for the city of Chicago doing constitutional and commercial litigation. And then I moved to a mid-sized law firm for the rest of my career, two mid-sized law firms, doing commercial and tort and municipal litigation, really on both sides, which you can do when you do commercial litigation. And I'm doing a lot of pro bono work in the interim from a law firm platform with colleagues who were supportive of that and partnering with different organizations to do work for people on a pro bono basis. And also, of course, Michael Bergman would not want me to omit that I've been on the Pilley board, and that was a big part of my life for both before and while I'm on the bench. So in 2015, I applied to be considered for an appointment to the state court at the circuit court level. And I was appointed, but the appointment had an expiration date. One of the judges had retired, and so that term was going to expire the following year. And so I ran for office countywide. So I am an elected judge. In Illinois, for the state court, we have roughly half of us are elected by the voters, and the other half are selected through an associate judge process, and they are selected by the elected judges. So we have those different pathways to the judiciary in Illinois, plus the appointment route, which I sort of put on the beginning, but that has an expiration. So I ran countywide in Cook County. I was fortunate and won. And so I have a 6-year term. And then every 6 years, the elected judges come up for retention, which is a yes/no vote. There's 2 boxes by your name, and there's a long list of us way at the bottom of the ballot. And you need to have 60% or more of the people who get all the way down to your spot on the ballot to vote yes for you in order to be retained. So that's just a little bit about how we formulate our judiciary in the state court. So when I got on the bench, I started in traffic court, as really every member of our Cook County judiciary does. I'm such a more cautious driver now. I mean, it's like night and day. All my family notices, because boy, do you see a lot in traffic court. But it is a great place to start developing your skills as a new judge for making disciplined decisions in high volume courtrooms and having to do it quickly in a way that I just did not have to do at the law firm. We had time to deliberate and ponder, and it's just a very different arena, and it's a really good starting ground for a judge, no matter where you end up going on the bench. Then after that, I went to the first municipal district in Cook County, which, as Brent said, is generally civil cases under $30,000, lots of car accidents, lots of housing disputes. I did 111 jury trials there. They were usually day long, sometimes 2 days long, but really interesting and also very good experience on that side of the bench to learn how to work with our good folks who come in for jury trial and get verdicts. Then a year and a half ago, I moved to the General Chancery Division in Cook County, which hears all kinds of cases involving all kinds of very interesting issues where some kind of relief in addition to or other than money is requested, which is barely captures all the different kind of cases that come across the bench, but it's a terrific assignment and I'm really enjoying it.
Thank you, Judge Conlon. Judge Hunt, tell us a little bit more about how you got to the bench.
All right. Thank you so much, Brent, again, for this invitation. I'm so excited to be here. I always love coming back and speaking to the Pilley students. I still remember fondly when I was a Pilley fellow way back when, graduating from law school. It was such a transformative experience. That's a really great way to put it, because it was a fantastic way to start off my career. I knew that I wanted to go into public service, but I couldn't afford to do that because I had law school loans to repay. And secondly, I also thought to myself, I don't even know if I'm mature enough to handle this kind of work. I mean, the people who are doing the legal aid work day in and day out really are very amazing. But being at the Legal Assistance Foundation really, kind of established for me the fact that no matter what I did, public service would be this theme that would run through my career. So I have done everything. I just like trying different things. So I started off at a big law firm. I was there for 3 years. They allowed me to bring some of my Pilley cases with me, and they were very supportive of pro bono work, which I think is something that is really very important. That is a change in law firms. Most law firms now are very, very open to that. And it's something you really should consider if you find yourself, I'm in big law, I'd rather be somewhere else, but there are still ways to give back. And we need big law folks to give back. So I did that for 3 years, and then I went to the 7th Circuit as a staff attorney. So a lot of my decision making came about because I had kids. I had my first child. She was a little unexpected and didn't, I was just starting my career, but oh well, there she was. And so I left the law firm because I needed better work-life balance. And so I went, and I also loved research and writing. So I started off at the 7th Circuit Court of Appeals as a staff attorney. I stayed there for 3 years. I had my second child. He also was somewhat unexpected too. But, at that point, you're kind of rolling along and you're like, all right, fine, another kid. But that really changed the trajectory of, my career path, because I was a parent and my husband traveled a lot for his job. And so I needed to have flexibility to be there with the kids. And so when I left the Seventh Circuit, I went to the district court as a law clerk there because I really liked research and writing, and I liked working around judges. I thought to myself, maybe one day I'd like to do this, but not really. I mean, I just never thought anybody would pick me, honestly, to do it. And so, but I loved doing that kind of work. I loved the deliberative process, the making decisions, the being the one trying to get it right really appealed to me. So once that clerkship ended, I went to the U.S. Attorney's Office on the civil side. Everybody thinks about the prosecutors, but there's also an entire civil division, and we defend lawsuits filed against the federal government and different agencies. And I really, really loved that work. I love litigation, and I loved feeling like, there is something exciting about stepping up and saying, I'm representing the United States of America, and feeling like we get to try to do things the right way. But as is a theme in my life, I had a third kid a little unexpectedly. And so I had to switch gears once more. And I then decided to leave the U.S. Attorney's Office because it was really difficult litigating with 3 children under the age of 10. And I went to a not-for-profit for a little bit and worked there because, again, it was about public service and about finding things to do that were meaningful for me, but that allowed flexibility for my family. After that, I went in-house for a couple of years at Exelon, and I was doing, utility work and litigation and, general litigation stuff. But I had a chance to start working on bankruptcy matters, and I didn't do a whole lot on it because we had outside counsel. I had taken the course in law school, but that was the extent of it. So I got a chance to at least look at, what happens in these big bankruptcy cases and think about how that might impact the utility company. But that was pretty much it. So I left Exelon, and I went back to the U.S. Attorney's Office because I honestly missed litigating, and my kids were a little bit older, and I said, okay, I think I can do this now. I eventually left the U.S. Attorney's Office and went to work for the state because I became the chief legal counsel of the Illinois Department of Corrections, which was for me a first leading a legal department. So at that point, it was kind of like, even though I loved the U.S. Attorney's Office, I knew I needed a different type of experience if I was going to start preparing myself for applying to the bench. And so I was there for a little bit, and that was a really hard but really important job, working on criminal justice reform issues and dealing with a lot of complex litigation. I ended up switching over to the Illinois Department of Central Management Services, another agency, and then I was appointed to the bankruptcy bench 4 years ago. I will say I applied for a bankruptcy judgeship even though I had never been a bankruptcy lawyer. You hear nothing in there about me practicing bankruptcy law. I was not. And so, and the Seventh Circuit actually appoints the bankruptcy judges. And so kind of came back full circle because many of the judges I had worked for as a staff attorney were still there. And they were the ones who were voting for me and who put a lot of confidence in me in giving me this opportunity. And so, it was a winding path. I never would have thought that I would be a bankruptcy judge. I absolutely love it. It is one of the, best ways for me to give back and to try to help out. Sometimes I can only do so much when people are in financial distress, but it really has been a great, career, and I love doing it, and I'm really happy that I have the opportunity.
Thanks, John. So some interns and fellows have already submitted some questions already to me, but I want to be able to make sure that you all ask the questions that you want to ask and hear from the judges. And so chat me if you have questions, and I'll tee it up for you to ask those questions, or can ask them if you prefer to remain off camera, can also ask them through me. But our first question comes from McKenna. So McKenna, do you want to ask your question?
Yes, thank you. So thank you, Sri, for being here today. My question is, what is the biggest mistake you see young attorneys make, and do you have advice for them?
So who wants to tackle that one first?
Usually I have an answer right away because I'm a mom. I always have something to say, but the biggest mistake, so I'll tell you the biggest mistake that I made as a young lawyer was really doubting myself a lot and not seeking out mentors as soon as I probably should have. And I say that because it affects the way you feel about yourself, and the way you see and perceive yourself affects the experiences that you have. And so I remember when I had a tough time at the law firm, and I, didn't know how to navigate, and I felt very isolated and alone. And I eventually found a mentor who kind of helped me to find my way. But a lot of it stemmed from this sense of I'm all alone. I'm very different. I don't feel like I fit in here. Now I'm starting to doubt, can I even do this job at all? And not realizing that everybody feels that way. We all have those imposter syndrome moments, but just knowing that, don't kind of stay in that rut, because it really did affect how I felt about myself and the work that I was doing. So I would say the big mistake is not seeking mentors early enough. You need a support network, whether it's an affinity bar association or, whoever. You need a support network, because this is a hard job to do, being a lawyer.
Yeah, I agree with everything Judge Hunt said. I think, especially if you don't have lawyers in your family, and you didn't know lawyers as family friends, there is this kind of outsider and imposter syndrome, for sure. With regard to new attorneys in terms of their litigation practice, and this is not necessarily confined to new attorneys, but maybe the problem is a bit more intense. There is the fear of saying, I don't know, like when that is the answer. I think your credibility as a lawyer is just paramount. And so when a judge asks you a question, and the answers are probably yes, no, or I don't know. And if it's I don't know, please go ahead and say that. It's perfectly fine. We don't know a lot of things, and maybe something that you need to go check the record and then file a supplemental brief later. Or you just don't know the answer. That's that honesty, that credibility is something you just need to preserve at all times. And I think it's all the more important, even though there's so many judges, because as I found out when I arrived on the bench, judges are awfully gossipy. We are terrible gossips when it comes to lawyers, and so the first. And I mean, I had some sense this went on, but when I got on the bench, that first week, going out to lunch and getting coffee with judges, getting to know them, they would ask me like, oh, so who's in this case that you've got, and then they'll launch into a 10-minute summary of what they think of that lawyer, and it happens again and again and again. So your reputation gets around pretty quickly too. So just suppress the ego, and if you don't know something, just say you don't know.
Judge Chang's advice about saying I don't know caused me to think of something, which is I feel like a lot of younger lawyers in particular assume that I know more than I do, and look to me like I should just know the black letter law for everything. And if a lawyer is struggling with an answer, chances are I'm struggling too. Things are, especially where I'm sitting now, but even back in a car accident trial room, I didn't know how to do everything. And sometimes young lawyers would just come in and be like, how do we do this? And I would just want to say, you tell me, that's why you're here. Also, just asking questions. I personally love to be asked questions, especially as you get closer to trial, which very few people actually get to in a civil context. Judge, how do you like us to get this to you? What do you expect from us at our pretrial conference? Things like that. You're going to have to ask about that, because one of the lawyer's big complaints, which is well-founded, is that each judge does things differently. I understand that so much better now that I'm on this side of the bench. Of course we do. We're all different people, and we're not automatons. You know, we do things in the way that we think makes the best sense. So asking questions. And last but not least, as I am aging, there is a generational gap between me and some of the youngest lawyers. And, you know, the next generation is a lot less formal than my generation, and mine is a lot less formal than my parents, and that's all okay. I love seeing young people in the courtroom. I love seeing the enthusiasm, the eagerness, and just the sense of pride of being there. I would just caution you to remember that you are in a multi-generational setting, and court is a really formal and very serious place for people who are there. Unless you're there in the Daily Center for an adoption or to pick up your marriage license, it's a serious weighty thing. And so to greet it with the formality that it merits, and understand sort of the larger context of where you are, and raise the level of formality accordingly.
Great. So I was chatted a question from Vanessa. How have you overcome or embraced the going from the biases of advocating and the kind of political barriers from advocating as an attorney, and then moving to the bench? So I think there's some, like, how do you navigate any political barriers, but then also the biases from being an attorney to being that unbiased judge in the black robe? Judge Chang, do you want to take this one first?
Yeah, sure. So it's in some ways I was fortunate, because my last job before taking the bench was as chief of appeals in the U.S. Attorney's Office, and a large part of my job was counseling the office on what would the Seventh Circuit think about a particular charge or a jury instruction or piece of evidence and so on. And so I had started doing that in my what was supposed to be an advocacy role, still was in a counseling role, trying to just think in that more balanced way. Now on the bench itself, I think we all come to the bench with certain preconceptions, and we do have to work hard on making sure that we are appreciating all perspectives. One way to do that is to set up rigorous processes, right? So you're not looking for a particular substantive outcome, but the process leading up to it. So for example, whenever I talk with the law clerk about a motion and what the draft opinion is going to look like, I always tell them, don't look on, we have this case organizational system, and all my notes about the case and the motion are contained in that system. I tell them, don't look at that before you come to your own conclusions about what the outcome ought to be and what the reasoning ought to be. So don't look at that. And then, of course, I'm not previewing anything that that they've been looking at. So we come at it independently when we have what I call an opinion conference. And I always ask the law clerk to present first. And then even if my notes are in 100% agreement with what the law clerk has presented, I will play just the devil's advocate and ask questions about, well, what's the best argument the other side has on this point? And so you just set up a process by which hopefully it scrubs out some of those preconceptions.
That's fun. Do you want to tackle that?
Yeah, I mean, I will say that it's nice being the neutral instead of coming to it and having to take a particular position. I will say where my struggle has been is because I was a trial lawyer, you have to learn to shut that part of your mind off a little bit, because I'm always thinking, why haven't they told me this? What about that? And initially I would ask those questions, and then I had to learn not to ask them, because as a judge, the parties tell me what they want me to know. And I can ask clarifying questions because, if I'm way off, I think the attorneys want to steer me in the right direction. But why didn't you do it the way I probably would have done it is something that I had to very quickly learn to move away from. I remember when I clerked for my district judge, he had been a prosecutor in Cook County for a number of years. And he would say, you know, there were some days he just wanted to take off his robe, step down and say, here, let me show you how you do this. But we can't. We're there to hear the evidence. We're there to, you know, consider the law and rule on it. And I think that's been the biggest shift, is kind of shutting that side of my own mind down enough to allow the parties to drive this, as opposed to me as the judge. And so, yes, it takes a very deliberate, I'm not going to ask that question, even though I want to ask that question.
These are all, it's interesting for me to be able to listen to my colleagues and their reactions. I would add that when I handled a lot of housing issues with people, there were a lot of self-represented litigants, especially in evictions. There are some very clear issues arising from race, from class, from disproportionately women being evicted, disproportionately women of color. And it was interesting because many people, and it's a very divided bar. It's a bar where you do not see landlords, lawyers really ever representing tenants or vice versa. So it's very positionally segregated. And it was interesting because from each side, you would hear very often landlords, lawyers saying, this is a deadbeat tenant. I mean, literally almost calling people names in court, which is not really something I was accustomed to as a boring commercial lawyer. And then you would hear tenants saying, this guy's a slumlord, and really kind of encouraging me to pretty, you know, directly to fall into patterns of just seeing somebody a certain way because of the label. I agree that, you know, having checklists of procedures became incredibly important, just to make sure that I wasn't slipping into an area where, as I said, like many people kind of clearly wanted me to go. We have lots of judicial education in Illinois, which I'm deeply, probably too deeply involved in planning. And implicit bias is always a core topic that we're thinking about, pressing ourselves about, talking about, reading about, studying. And one final thing I'll say is that I've noticed in Chancery, I do a ton of reading of really good legal briefs, and it always starts out a motion, a response, a reply. That's typical sequence for legal briefing. And many, many times I'll read the first paper and I'll go, yeah, at the end, yeah, that was really, that makes a lot of sense. Wow, I wonder what that other side's going to say. And I might even be a little dubious that they can come up with something. And guess what? You read the next step, you think, wow, that was, and by the time I'm 2/3 of the way through, I honestly don't know where it will come out. There's a lot of more work to be done. So it's a constant way of reminding yourself, starting to think about that, a difficult instruction that we give jurors. Don't start to consider any piece of evidence until you've heard all of it come in. It's very hard for us in regular life to do that, but I have learned in these 6 years that it's so important, because truly, if I judged on that first brief or the first half of it, I'd probably end up making a mistake.
All right, our next question comes from Ben. Ben, do you want to unmute yourself and ask the question?
Yeah, thanks, Brett. Can you hear me?
Yep.
Awesome. So I had a question. So a lot of you come from kind of more advocacy, public interest backgrounds as an attorney before being a judge. Are there ways that you maybe outside of the courtroom still are involved in those sort of endeavors? Or do you kind of see that once you become a judge, it becomes difficult to be involved in any sort of advocacy work if you are interested in that public interest work?
Well, I'll start. As federal employees, we have a number of restrictions because we are technically supposed to be very apolitical. And so we pay close attention to what we can do and what we can't do. I mean, and some of that is also just because a position, particularly for Judge Chang being in district court, I mean, a certain issue might come before him and he has to make a ruling on that. And so we just have a number of restrictions, and we are, you know, can't be as actively involved in advocacy as maybe, you know, we might have been when we were private citizens. I mean, one of the things about having come from the U.S. Attorney's Office, we had many of the same restrictions. And so I'm kind of used to not being in that role and always having to say, I can't, you know, be involved in things politically or other types of organizations. But I will say that, you know, I think we're all of us are very active on different boards. On the Chicago Bar Foundation. They have an advocacy arm that is, you know, attached to that organization. I've stayed involved with PILI. I think there's plenty that we can do. We just can't really use the fact that we're federal judges to try to influence what might happen. And so that's one of the things that I'm very careful about. And I read the ethics desk book that they gave to us just to make sure we're not crossing any lines, because it really is important that the public sees us as fair and impartial jurists when I am on the bench and when I am not on the bench, because unfortunately I'm still Judge LaShonda Hunt no matter where I go. And it took a long time to understand that I have to be careful with that. And so, yes, we are, you know, all in, and certainly in my own way, I serve on different boards and different committees and work with groups to continue to push forward the issues that I personally think are important, but I have to walk a very fine line.
Yeah, I mean, Judge Hunt is exactly right. We have the Judicial Code of Conduct that governs, you know, what we can do in numerous ways. And there are well over 100 advisory opinions interpreting those canons. And so and of course, we do place a premium on not just, you know, actual fairness, but the appearance of fairness and the appearance of no bias. That does sometimes pressure, you know, it does place pressure on you, like personally. There are, you know, events, especially last year, you know, where you might feel very strongly about it on a personal level, but because of the positions that we're in, we can't take a public stance, you know, on these things. And I mean, just to show you the care and caution that we take, we had an orientation for incoming law clerks who have their own judicial code, code of conduct for judicial employees, and they're governed by that. And because they're chambers employees, it's quite similar to the restrictions on the judges themselves. There's a little bit more leeway for clerk's office employees and so on, but the chambers employees, and yeah, we actually had to have a discussion on, could you post on social media about paying respects to Justice Ginsburg when she passed? I mean, that's you would think that, of course, you know, there should be an outpouring of grief and respect, but you actually have to like take a moment and think about, like, is that actually consistent with the canons? That's how, you know, really strict they are. And actually, it's one thing for those of you who are thinking about applying to clerkships, that is the kind of rigor that we apply to public statements, or even if you have a private setting on your Instagram or Facebook, it's, you know, it's still any kind of social media, you know, we expect that same kind of appearance of absolute zero bias. And it could be, it does put a lot of pressure on you personally.
Mm-hmm.
Judge Conley?
From a state court perspective, the strictures placed on us are different from the federal ones. And I mean, a big reason for that is that roughly half of our judges do run for office, and we do align with a political party for that time. But there are still very similar restrictions on us taking any type of political positions. And so where I've remained active is number one, on boards, as Judge Hunt alluded to. both Pilley and the Bar Foundation, and also a startup youth debate organization that has been a lot of fun and very rewarding. But I actually don't think I'm the best board candidate that people can find, because I cannot fundraise. And that is what the majority of nonprofit boards need. And I just can't do it. So people have been very kind to me about that restriction, but it really limits my efficacy outside of the legal world. We are expressly allowed to do outside activities that promote justice and sort of court operations. And so I am a co-chair of a Cook County Pro Se Advisory Committee, which is comprised of a number of stakeholders. And what we do is propose new rules for the circuit court and new approaches to doing things, which I do think is a form of advocacy for sure. But I find it very consistent with the canons, because I think, you know, one of my colleagues says, as a judge, we're advocates for justice and, you know, advocates for access. And so most of my focus is on access to justice type initiatives where I'm very comfortable that I can participate fully or almost fully and not do anything that would run afoul of the canons.
So for our next question, can you all talk a little bit more about pro se and self-represented litigants and the impact on more pro se individuals in court proceedings, and what happens when people don't have representation? How have you seen this change, either in a positive or negative way, due to COVID and court proceedings over Zoom? And then any role that new attorneys can play in helping address access to justice and have more people who don't have representation to get an equal chance through the justice system. So that I know that was a lot, if anyone wants to tackle that first.
The last part of that is really easy. Stay involved and connected with Pilley. And support those initiatives, whether you support it because you are doing pro bono work, or you are giving financially, or you are serving on a board. I think there are a number of ways to give back, but you have to be very intentional about that, because once you start working, like, real life kind of intrudes, and the demands of a job and the demands of family and life can push those good intentions to the sides. And so I think there are, you know, just plenty of things that you can do to support those efforts. And there are plenty of great organizations who are working in that space right now. So get involved. It's nice to have something else to focus on outside of work, where you're giving back to others. I think that makes us better lawyers, because it helps us to appreciate the perspective of self-represented litigants who are coming into this really scary system and don't understand what is going on. We have a unique skill set, and we can help them to navigate that space in a way that others cannot. I definitely see in bankruptcy court more pro se litigants showing up because they can show up on Zoom. They may not have been able to, you know, take time off of work to pay to come downtown and park and come into my courtroom, but they can show up on Zoom. And we are seeing that more and more. And that is one of the real benefits, is the way that the system has opened up to so many litigants who felt like they were not a part of it. Even them just being able to hear the judge speaking and hear the judge explain, this is why I'm ruling the way that I'm ruling, even when they have lawyers, is a good thing too. And so I think a lot of good will come out of, you know, this crazy pandemic, particularly for self-represented litigants, but there are still issues out there and they still need representation. And it's a great way for young lawyers to gain experience too.
Yeah, I think having come from the private sector too, I mean, I loved how pro bono engagements gave me an opportunity to be the first trusted advocate for somebody, that is such an exhilarating feeling. And if you're at a larger law firm on big teams, you're not the one with the closest client contact. I mean, I remember prepping one of my first pro bono clients for a deposition, and we needed a lot of prep work. So we had 3 different meetings. The total, I'm going to say we were in the double digits for the amount of prep we did, the hours. And I didn't know how this was going to go. And boy, did she deliver. And I remember jumping up and down and hugging her. Like, we were both jumping up and down together. She did such a good job. How does it look on the other side? My former division, I mean, we had the majority of litigants were self-represented, and we had several ways that we could appoint civil attorneys in certain cases, but we certainly didn't have even close to enough attorneys. But we would be able to appoint some when people got close to trial. And I mean, what happened? Somebody who most likely would have lost at trial ended up getting a settlement because the other side saw a lawyer for the first time. I mean, that's sometimes the easiest way to dispose. And I've also seen lawyers who took pro bono clients to trial in my room and, I mean, just got results that were unbelievable. So, I mean, a game changer is an understatement. I will say as a caveat, I did some work in pro se court where nobody had a lawyer. And in the majority of cases, I was really pretty encouraged by how good of a job people do advocating for themselves if it's a level playing field, a fair proceeding, and it's not imbalanced where one side has a lawyer and one doesn't. Pro se court was just wildly interesting. And it was not high volume. And so there was enough time to really get into things and get to the truth. And I think, and I hope, make people feel heard. It's the cases where it becomes so lopsided, where there's a lawyer on one side and one that's not, where it's going to be really hard to get to the truth if you don't have a lawyer who can help navigate the client there.
Mhm.
Yeah, I agree with all of that. I think in some areas of the law in which pro se cases are prevalent, like habeas, Section 1983 civil rights cases, it is really difficult for lawyers to navigate, the body of law, let alone someone who does not have a law degree and often does not have advanced education. And so I represented a habeas petitioner, pro bono when I was at Sidley, and just to get an evidentiary hearing, it was really, really difficult, and took a lot of work in putting the petition together. And it is habeas law is just a labyrinth, to navigate all around the procedural defaults and traps and exhaustion and so on. So it makes all the difference in the world in these really complex areas of the law. And then, from this side, we do have a trial bar of attorneys on the Northern District of Illinois. It's a few thousand attorneys actually that we can draw upon to ask them. We ask them, but we really, we're assigning them to, represent someone pro se. And the vast majority of them view it as a privilege, as a public service that they ought to deliver on. Some don't. We do have some recalcitrant lawyers on this, and we try to find other ways for them to serve, as opposed to just basically inflicting them on a client. Like they might staff the help desk, the pro se help desk that we have in the Northern District for 4 days out of the year or something. But again, the vast majority take on these cases and do a great job, and it makes a huge difference. There was one case that went all the way to trial. It was a prisoner civil rights case in which the prisoner alleged excessive force against guards, who he says just beat him forcibly in order to bring him to the doctor's office because he was on a hunger strike and they were going to force feed him. And so this case starts out without a lawyer. There's no way he's going to navigate this kind of a case. I recruited a lawyer through just really vigorous discovery practice. The lawyer was able to unearth a video of the extraction, and the guards settled like that right after that video came to light. And then the doctor went to trial. And the allegation there was that the prisoner had been pepper sprayed. And so he still had the chemical in his face, but the doctor was taking the tube and still and pushing the tube down, but it was picking up the pepper spray going down his throat. And so again, very vigorous depositions. The appointed lawyer, I think he took about 12 depositions. One of the guards told the truth, at least according to, and he just testified contrary to what everyone else, all the other guards said, and the jury credited that guard, and they found in favor of the inmate. So no way any of that could have happened without an appointed lawyer. So I certainly urge you to continue to do pro bono work in your careers.
Thank you, Judge Chang. So this will probably be our last question. So first, for Judge Hunt and Judge Chang, I wonder if you could tell us a little bit more about the impact of your Pilley Fellowship, personally and professionally, and then any advice that you have for making the most of your Pilley experience. And then Judge Conlon, maybe you can close us out with, as a Pilley board member, you've had a lot of experience with Pilley interns and a mentor for Pilley interns for a number of years. So any advice that you have for our Pilley interns this summer. But let's start with Judge Hunt.
Sure. Thank you again, Brent, and thank you to all of the students for being here. This really is, Pilley was such a game changer for me. It was one of the best ways to start off my legal career, working with such talented and committed lawyers who really took me under their wing, took me over to the Daily Center, introduced me to people, explained what they did, why they did it. I think it was just such a wonderful example of seeing lawyers who were working, under some really challenging situations. They weren't being paid. They aren't paid what big law firm lawyers are paid. They don't have all of the resources. The clients have a lot more issues than they have solutions for. But these attorneys were so dedicated. It really made me see what lawyers can do and how much of an impact, a positive impact we can have on the legal system and ensuring that it's, fair and efficient and everybody has, access to justice. And so I just, have never forgotten that experience. And it's why I've stayed involved with Pilley. I think I'm now a Justice Society member. And so I contribute financially because I think it's really important to support this work. My, sort of advice is just enjoy this moment, take full advantage of this opportunity to learn everything that you can. Even if you discover, I don't think I want to, do that kind of work, that's okay. But just, it's, it's such a wonderful way to really understand what the legal system should be and what we can do. And so just enjoy the summer, learn from as many people as you can, take on as many challenging projects as you can, because that is, what will make you a better lawyer.
Thank you. Judge Chang.
Yeah, as I said earlier, the fellowship really was eye-opening in being able to see the perspective of criminal defendants and the impact that these prosecutions have on their family as well. And I think, like Judge Hunt, seeing these lawyers in action and then working with them to take care of these people, it was it really does instill that love for public service, and it also taught me the lesson of just that your work ethic has to be kind of at a maximum. Of course, take care of yourself and take care of your family, but your work ethic, in order to solve these problems for these clients, you do have to maintain it at a very high level. And I just saw how much effort Mark Kadish was one of the lawyers there, just a renowned criminal defense lawyer, and just how hard he worked and how caring he was with the clients. but also candid with them too. You know, it's like the equivalent of tough love sometimes. Sometimes that's what the client needs as well. And then going forward, it certainly helped me when I was an assistant U.S. attorney in remembering to treat the defendant with dignity and respect. Okay, I believed he violated the law. He's going to face the consequences for that. That doesn't mean that he's undeserving of dignity and respect, and certainly his family as well. So it has helped me keep that balance, just the open-mindedness throughout my career, and I hope those values are instilled in you as well.
Judge Conlon, close us out.
Okay, this board member says that obviously looking at Judge Chang, Judge Hunt, you're in such a good group right now, right? Look at this pipeline you found yourselves in with all these great people ahead of you who have done what you're doing this summer for all the good reasons they've talked about. I encourage you to reach out to people ahead of you, to not be shy with questions, and to also remember what you can bring to these noble endeavors. Right now, you're new to the profession. We need new people in the profession, if for nothing else, to teach us old people about technology, which has been some of the greatest contributions my law clerks have made this year in keeping us going during remote times. You all tend to be better at that than people ahead of you, so you can contribute that. We're also living in extremely rich times. You know, there's been a lot that's happened in the world, and your perspectives on that are so valuable. So I can't wait to hear about what you get out of the experience from observing and interfacing with everybody. And I'm confident you're going to just contribute as much. So congratulations.
Well, thank you all, Judge Chang, Judge Alison Conlon, and Judge LaShonda Hunt. Thank you three for joining us and sharing your wisdom and your thoughts from the bench. It's always wonderful to have you all. So as I like to say, dozens of muted applause to all three of you. And thank you everyone for joining us today. Pili will be back next week on Tuesday, June 15th for our next session on engaging with your community. So thank you for joining us today, and we'll see you all next week. Thank you.
Thank you, Brent.
Take care.
Take care.